Hello everyone. Today we are going to discuss about the topic agency law and wherein we'll understand who is principal, who is agent and all the different concepts with regard to agency law. So the topic which we are going to cover today is with respect to agency law when we are going to understand who is an agent, and we will also understand that how an agent is appointed, what type of agreement is made between a principal and an agent. And not only that, we are also going to understand what are the authorities or powers of an agent and what are the different liabilities of both the principal as well as agent. So let's start with the topic of agency law. Now, before we start with the topic, let's take an example and understand what exactly like. So, when we talk of a principal-agent relationship, there are two people who come in our mind. There has to be a principal and there has to be an agent. Now, let's say, for example, there's a person, Mr. Vijay, who carries on his business in Delhi. So Mr. Vijay is carrying on his business in Delhi. Now, Mr. Vijay's business is expanding, as a result of which he starts getting orders from the state of Uttar Pradesh as well. So, since Mr. Vijay's business is expanding, Mr. Vijay starts getting orders from UP as well. But Mr. Vijay does not have any physical presence in UP, or Mr. Vijay does not have any business establishment there in UP. So for which what Mr. Vijay does is Mr. Vijay contacts one of his friend in UP, Mr. Ajay. Mr. Vijay contacts Ajay and he asks Ajay that for the orders which I receive from the state of Uttar Pradesh, you please take care of these orders and you make sure that these orders are fulfilled on time. So what is happening here? Mr. Vijay, who has his presence in Delhi, he starts receiving order from some other state. And when he is receiving order from a state when he does not have any physical presence, he appoints a person who will act on his behalf in Uttar Pradesh. So Vijay has appointed Ajay, who is going to take care of his orders from this state of Uttar Pradesh and who is going to fulfill the orders in the state of Uttar Pradesh. So here in this situation, Mr. Ajay is acting on behalf of Mr. Vijay. He is acting on behalf of Mr. Vijay. So Mr. Ajay in this situation has been authorized by Mr. Vijay that he will take care of the orders from the state of Uttar Pradesh. So Mr. Ajay is not acting in his individual capacity, but rather Mr. Ajay is acting on behalf of Mr. Vijay and he is acting as Mr. Vijay's agent. So in this situation, there's a principal agent relationship which has been established between Vijay and Ajay, wherein Vijay is the principal and Ajay is acting on behalf of Vijay, which makes Ajay the agent of Vijay. So now in the state of Uttar Pradesh, whoever is the customer or whoever approaches Ajay, third parties who are approaching Ajay and Ajay entering into contract with third parties, Ajay is entering into contract with third parties on behalf of Mr. Vijay. Which means, say for example, Ajay has entered into a contract with a customer in Uttar Pradesh. This contract will also bind Mr. Vijay. Why is that so? Because Mr. Ajay is acting on behalf of Mr. Vijay. Ajay is acting as Vijay's agent, and that's the reason why Ajay has the binding authority. Ajay's contracts on behalf of Mr. Vijay will bind Mr. Vijay as well. So there's no direct contract which is taking place between Vijay and third party, but rather the agent Ajay is acting on behalf of Vijay and entering into a contract with a third party. So, which in turn binds Vijay as well. So, this is what happens in case of agency. So, agency is basically a relationship between a principal and an agent, wherein the agent enters into contracts with third parties or enters into transactions on behalf of the principal, and he has got the authority to bind the principal. So this is what happens in case of agency. So let's now understand what are the different things we are going to study in this topic of agency law. So we are first going to understand the definition of agent, who is an agent, and then we'll understand how the principal agent relationship arises, as in how is the contract or how's the agreement between the principal and the agent made. So how does the principal agent relationship arise? Then we'll understand the authority of agent, what are the powers which an agent have, and finally understand the liabilities of a principal in case of a contract of in case of an agency which is being formed. So let's now first have a look at the definition of the agent. So let's now have a look at the definition of agent. So an agent is a person who is authorized to act for another. So as we've understood, an agent is a person who is acting on behalf of the principal. So an agent is a person who is authorized to act on behalf of another, that is the principal, in making of legal relations with third parties. So in our example, wherein the third party in UP is entering into a transaction with the agent. So there's a legal relation which has been formed. It is the agent who is entering into the transaction with third party, but he is also binding the principal. How is he binding the principal? He is able to bind the principal because he is acting on behalf of the principal. He is authorized by the principal to act on his behalf. So an agent is basically a person who is authorized to act on behalf of the principal in making legal relationships with the third parties. And the resulting contracts are made between the principal and the third party. Though it is the agent who is entering into the transaction, but the contracts which arise are the contracts between the principal and the third parties and not directly with the agent. So the contracts which are being made are contracts between the principal and the third party and not directly with the agent. So there are a lot of situations wherein this agency relationship exists. When we are talking of company, the directors of the company, they act as agents of the company. Or when we are talking of a partnership, the partners, they act as agents of the partnership. Say for example, someone wants to sell a house, they appoint a real estate agent, so that real estate agent is acting on behalf of this person who wants to sell the house. And similarly, you might have heard of travel agents. Whenever you want to plan a vacation, you approach a travel agent who makes sure who makes sure of all your travel arrangements. So there are travel agents who have been appointed by different people, or even say there are these Make My Trips and Go Ibibo, different companies. So they have a different set of travel agents which they have appointed and who work for them. So there is an agency relationship which arises in several situations. It is not only with the business perspective, but there are different situations where this agency relationship arises. So when a partner is acting or when a partner is entering into any transaction on behalf of the firm, the partner binds the firm with the transaction which he's entering into. So there are different situations where this agency relationship arises. Now, the other question which comes up here is that how does this agency relationship arise? What gives rise to agency relationship? Let's understand it. So when we talk of how does the agency relationship arise, so the first situation is very simple. It is by an express agreement. So in the example which we had taken above of Mr. Vijay and Ajay, therein there was an express agreement between Ajay and Vijay, wherein Vijay authorized Ajay to act on his behalf. So in that situation, what is happening? When we talk of an express agreement, we are saying that the terms of agency have been agreed upon between the principal and the agent, either orally or in writing. So that's when we say that the agency relationship has arisen through an express agreement. So there's an express agreement. The term express itself specifies that all the terms and conditions with respect to the agency, the authority which has been given under the agency has been expressly agreed upon between the parties. So we say that there's an express agreement. Apart from express agreement, what is the other way or what is the other manner in which the agency relationship arises? The other case is an implied agreement. Now, when we use the word implied basically means it is by implication. So there is no expression of terms either orally or in writing, but the conduct of the parties is such that there's an implication that one person is acting as an agent of the other. So here, when we talk of implied agreements, there's no specific agreement. There's no specific agreement either orally or in writing which has been entered into. But the conduct of the parties is such that which gives an implication that there is a principal agent relationship between the parties. So that type of an agreement is an implied agreement. The next is agency by necessity. Now, what does this mean? Let's understand. So, in certain situations, there would be some emergency situation which would arise, and the next case is agency by necessity. Now, there could be some situation where some emergency has arisen, and it is not possible for the agent to contact the principal or to communicate with the principal. Let's understand this with help of an example. Now, say there's a person, Mr. Raj, and Mr. Raj is acting as an agent of Mr. Aki. So, Mr. Raj, he is acting as an agent of Mr. Aki. Now, Raj, he was entrusted with the task of taking goods from one place to another. So, say he had to take goods, say from Delhi to Jammu. But on the way, what happened was there was a landslide. Due to bad weather conditions, there was a landslide which had happened. Now, Mr. Raj, he cannot take this truck ahead because of the landslide. He cannot go ahead. And also, it is not possible for Mr. Raj to contact Mr. Aki because the weather condition is so bad, there's no proper network. But Mr. Raj has to make sure that the goods are safe. Now, the goods are lying in a truck, and the weather is very bad. It is raining heavily. There's storm and rain everywhere. Now, Mr. Raj has to protect the goods. Now, for which what he does is he finds a warehouse. He finds a warehouse or say a godown, and that place had ample space to store these goods which were in the truck. So Mr. Raj, what he does is he decides to store these goods to shift the goods from truck to this godown, so that whenever the weather is fine, he will again load the goods into the truck and take the goods to Jammu. So here in the situation, before deciding upon storage of goods in the warehouse or storage of goods in the godown, Raj could not take Aki's permission. And Raj, if he is using this godown, he'll also have to pay some charges. No one is going to let Raj use the godown for free for storage of goods. Definitely not. So in this situation, Raj, he has acted in an emergency situation. This is an emergency. If Raj wouldn't have shifted the goods to the godown, then the goods would have destroyed. So, in order to protect the goods, Raj had to act in a manner wherein he stores the goods in the godown and protects the goods. So, in the situation, there was some necessity or there was an emergency situation which arose, because of which the agent had to act exceeding his authority or without the prior approval or without any communication from the principal. So in this situation, do you think Aki will be liable to pay these charges of the godowns to Raj? Yes, he definitely has to pay. Aki cannot say that no, I did not ask you to store the goods in the godown and I'll not pay these charges. Aki will have to pay these charges because in the situation, Raj, there was an emergency situation which had arisen, and Raj had taken reasonable steps only and only to protect the goods. So in the situation, Aki will be bound to pay these charges, to reimburse these charges to Raj. So this is what happens in case of agency by necessity. So there's some emergency situation which is arised, because of which there's some action which the agent has taken. The next case is agency by ratification. Now, what happens in case of ratification is wherein the agent has exceeded his authority. Now, what does exceeding authority mean? Say, for example, a person is acting as an agent for a financing company. And this person, he has been given the authority to grant loans only at up to an amount of rupees 2 lakh. But this agent, he grants a loan of an amount of rupees 5 lakh. Now, he was eligible to grant loan up to 2 lakh, but he has sanctioned a loan of rupees 5 lakh. Now, in this situation, say if the financing authority, they say, okay, fine, no problem, we approve this transaction. So what is happening? Though the agent has exceeded his authority, the principal, he has ratified or he has made valid the act of the agent. He has approved the act of an agent which was performed by an agent exceeding his authority. So in that situation, agency by ratification arises. And the last situation is agency by estoppel or agency by holding out. Ratification is wherein the agent has acted beyond his authority and the principal has ratified his act. Now, what happens in case of agency by estoppel? Let's understand. So, when we talk of agency by estoppel, there's no express agreement between the principal agent, wherein there's no principal agent relationship at all. But still, by estoppel, a principal agent relationship is established. Let's understand how. So, there's a person who wants to sell his house. Okay, there's a person who wants to sell his house, and he is informed. The name of this person is, say, Mr. Abhi. Abhi wants to sell his house, and he informed his friend Adi about his decision to sell his house. And Abhi went out of town. Abhi informed about his decision to sell his house to his friend Adi, and he goes out of town for some work. Now, meanwhile, when Abhi was out of town, what Adi does is, Adi, he informs his friend Mr. Chandu that Abhi wants to sell his house, and Chandu, he shows interest in purchasing Abhi's house, and he says, I'll pay rupees 2 crores for this house. I'll pay rupees 2 crores for this house, and let's make it a deal. Now Adi, he says, okay, fine, no problem. 2 crores is a good amount, and Abhi would be really happy if he gets this amount for his house. Now, in this situation, was Adi Abhi's agent? Answer is no. Abhi did not authorize Adi to enter into any transaction to sell his house. But still, here Adi is representing himself as Abhi's agent and entering into this transaction of sale of Abhi's house for rupees 2 crores to Chandu. Now, when Abhi returns, he comes to know about this particular thing, and he thinks, okay, fine, 2 crores is a good amount which I'm getting for the house. I wouldn't have got this amount if I would have advertised, I would have issued an advertisement. So in that situation, Abhi says, okay, fine, let's call it a deal. Let's make a deal. So in this situation, what happened? There was no actual principal agent relationship in between Abhi and Adi, but here Adi has acted as Abhi's agent by holding out. So this is similar to partner by estoppel or partner by holding out. Just like we have a partner in case of partnership who is not actually a partner but who is deemed to be a partner in certain situations. Similarly, here Adi is not actually an agent, but his actions they uh, they are in a manner which gives an impression that he is acting as Abhi's agent. So this is where agency arises by estoppel. So how does agency arises? It can be established in any one of the five ways: express agreement, implied agreement, necessity, ratification, or estoppel. So what happens in each of these situations? So when we are talking of express agreement, it is an actual situation wherein a person has been actually appointed as an agent, where the agreement is made either orally or in writing. When we talk of implied agreement, there's nothing which has been expressly agreed upon. However, it can be implied by the conduct or relationship between the parties. So it is something which is implied by the conduct or by the relationship which exists between the parties. So when we talk of agency by necessity, there are four conditions which shall be satisfied. The first one is property is entrusted to the agent. So in our example, there was some property which Mr. Raj had. Raj had the goods of principal, and an emergency arises, making it necessary for the agent to act. So there's some property which has been entrusted to the agent, and there's some situation which is arising which makes it necessary for the agent to take some action. It is not possible to communicate with the principal. It is not possible for the agent to communicate with the principal, and the agent acts in the interest of principal. So these four conditions have to be complied with. What are they? The first one is that there's some property which should be entrusted to the agent. There's some emergency situation which is arising. It is not possible for the agent to communicate with the principal. And the last situation is that the agent acts in the interest of the principal. So if all these four conditions have been complied with, we say that an agency by necessity has been created or has come into existence. Now there's one case law, Prager versus Blatchfield. Let's see what it says. The facts of the case are such: A bought skins as an agent for principal, but was unable to send them to principal because of the prevailing war condition. Since A was unable to communicate with P, he sold the skins before the end of the war. Now, in this situation, what has happened? The agent, he had bought some skins on behalf of the principal, but he could not send the skins to the principal because of the war conditions, and also was not able to communicate with the principal. So what the agent does is, agent, he sells off the skin. Now, in this situation, the agent selling the skin, was it required? Was it in the interest of principal? There is nothing has been mentioned that the skins would destroy or would perish if not sold. So there's nothing which has been mentioned as such about the damage or about the destruction of the skins. So in this situation, A was not an agent of necessity, because he could have stored the skins until the end of the war. So there was no real emergency which had actually arisen in such a situation. So when we say an agency by necessity, so there has to be an actual emergency situation, and the agent's act should actually be in the interest of the principal. Only then we say an agency by necessity has come into existence. The next case is Great Northern Railway versus Warfield. What happened here? The facts are, there was a contract between two parties whereby GNR agreed to transport the defendant's horse to a particular railway station from where it would be collected. When no one arrived to pick it up, the station master, having tried unsuccessfully to contact the defendant, placed the horse in a stable overnight. So what has happened? There was a contract wherein one party was to transport the horse to a particular railway station, and the horse would have been collected by the defendant from the railway station. But no one arrived to pick up the horse, and the station master, he tried contacting the defendant several times, but to no response. So as a result, what the station master does is, he then places the horse in the stable overnight. Now in the situation, GNR was entitled to recover the cost of stabling because it had become the agent of the defendant by necessity. So the horse had to be kept in the stable overnight. Now in the situation, they are entitled to recover these costs which have been incurred to put the horse into the stable from the from the defendant. So this is where there was an actual necessity which had arisen, and whenever there's a necessity situation, agency by necessity comes into play. Then by ratification, so if a properly appointed agent exceeds their authority, so there is a principal agent relationship, but the agent has exceeded his authority, or a person having no authority purports to act as an agent, the principal has no liability on that contract unless the principal ratifies the contract. So there can be two situations here. In the example which we had taken, the agent exceeded his authority and sanctioned a loan of 5 lakh rupees. In that situation, the principal has two options. They can either say yes, they can either approve the transaction, or they can not approve the transaction. So in such a situation, if the principal is ratifying the contract, then there's no problem. Agency by ratification arises. But if the principal does not ratify the contract, then the principal will have no liability in such a situation. The principal's liability will arise only when he ratifies, and not in a situation wherein he is not ratifying the contract. So that is when the agency by ratification is being talked about. So when we talk of ratification or agency by ratification, the effect of ratification is to backdate agent's authority as an agent. So this requires principal to have contractual capacity to make the contract. And the principal should have been in existence both at the time when the contract was made and on the date of ratification. So the principal has to be in existence both at the time, on the date when the contract was made, and also at the date of ratification. And the principal to be identified when the contract was made. So when the contract was being made, the principal should have been identifiable. The principal is aware of all the material facts, clearly signify their intention to ratify the whole contract within a reasonable time. So if the principal wants to ratify the contract, he has to clearly signify his intention to ratify the whole contract within a reasonable time. It is not that the principal will take their own sweet time to ratify the contract. No, that is not allowed. So they should clearly signify their intention to ratify and should be done within a reasonable time. So all these conditions shall be complied with when we are talking of agency by ratification. However, a void or illegal contract cannot be ratified. Now talking of by agency by estoppel, so as we have understood, they are not actually principal agent, but where P holds out that A is their agent even though they are not, the principal is then prevented or stopped from denying A's authority. So if the principal by his actions, he has made known, or he has made it evident that the person who is not actually his agent is acting as his agent, then later on principal cannot deny his authority. In our example, when Abhi agreed to this contract of 2 crore rupees, Abhi cannot later on say that no, Adi was not my agent. Say Abhi gets another offer and the other person is giving him 2.5 crore for the same house. Now Abhi says, let me cancel this contract which Adi has made, and let me take up this contract. I'm getting 2.5 crores. I'm getting extra money here. Abhi cannot later on deny his authority, deny Adi's authority, stating that Adi was never my agent, but I am not obligated, or I am not obligated to do anything which Adi has entered into. I am not bound by a transaction which Adi has entered into. So if the principal has one held out that a particular person is his agent, though he is not, then he cannot later on deny his liability. He cannot later on deny deny this person being his agent. So that is what agency by estoppel means. So these are the different ways in which the relationship or agency relationship is formed. Let's now talk about the authority which an agent has. Now, when we talk of the authority of the agent generally has the authority which has been entrusted to him by the principal. So the powers which the principal gives the agent has the authority to exercise those powers, and he cannot exceed the powers which have been given to him, which have been assigned to him by the principal. So the agent, he has to act within the authority which have been assigned to him by the principal. The powers of the agent are specified by the principal, and when an agent is acting within his authority, he will make the principal liable for all his acts, for all his actions which he is doing. But yes, if the agent exceeds the power, in that situation as well, the principal may be bound, provided that the principal ratifies the act which is being done by the agent. So let's now talk of the authority of the agent. So when we are talking of authority of the agent, it determines the powers that the agent has on behalf of the principal and for which acts the principal would be liable. What are the different ways in which the agent is given authority by the principal? First one is express authority. So when we talk of express authorities, it is something where the principal has explicitly given some powers to the agent. The principal has clearly specified that as my agent, you have these powers. So when we talk of express actual authority, it is wherein the principal has clearly specified that as my agent, you will have these powers. So where the powers have been clearly specified, we say that these are express authorities of the agent. However, in certain situations, the agent would also have certain implied authority. Now, what is that? An agent has implied authority to do things which are reasonably incidental to the performance of expressly authorized act. So if something is incidental to performance of an act which the agent is authorized to do, which means, say for example, there's one act which the agent is authorized to do, but in order to do that act, the agent also has to perform some other functions. So that other function, for those other functions, the agent need not need an express authority, but rather it is implied that if he has to do this, he has to complete the other thing as well. And if the agent is an agent occupying that position would usually have to have authority to do such transactions. Say for example, there's a financing company who is appointed agent, and that agent or agents of similar cadre, they have a right to sanction loan of up to rupees 10 lakhs, and there's no specific limit which has been assigned to this particular agent. So this agent who is occupying the position, who is occupying a similar position, agents of similar cadre, they have the authority to sanction loans up to 10 lakhs. So there's an implied authority that this agent who is occupying a similar position, he will also have the authority to do a similar kind of act. And also agent is authorized to do to something which is not expressly prohibited by the principal. If the principal has not expressly prohibited agent from doing a particular thing, then the agent can definitely perform that particular function, can definitely perform has a right, has an implied authority to perform such an act. Now, third type of authority is apparent or ostensible authority. So such authority arises when agent is held out by principal as having authority. So the representation by principal may arise from previous dealings, which allows the agent to make contracts in the past, is a representation that agent has authority to continue to do so in future. So if in the past by some actions the principal has authorized a person to act as his agent has entered into some transaction, has given some authority to the agent because of his actions, then we will assume, it will be deemed that the agent has authority to continue doing such acts in the future as well. So these are the different authorities which an agent has on behalf of the principal. If the agent acts beyond his powers, then in such a situation, two things may happen. One is the principal ratifies the act done by the agent. The second situation is principal does not ratify the agent's act. If the principal ratifies the act of the agent, then the principal will be bound by the transaction or the agreement which is made by the agent. However, if the principal does not ratify the act, then the agent will be liable to the third party. So, when the agent is acting beyond his power, when he is exceeding his authority, two things may happen. The principal ratifies the act which is being done by the agent beyond his powers. If the principal ratifies, then the principal will be liable for that. But if the principal does not ratify the act which is being done by the agent, then in such a situation, the agent will himself be liable to the third party. Why is that so? Because the agent has acted beyond his powers. So the agent's liability would still continue. Let's now talk about the liability of the principal for the acts which have been done by the agent. When we talk of the liability of principal for an act which has been done by the agent, there can be two situations. One is where the principal is a disclosed principal. The other is where the principal is an undisclosed principal. Disclosed principal basically means that the agent clearly specifies that I am acting on behalf of this particular person. And when we talk of undisclosed principal is basically a principal whose existence has not been made known to the third party, whose existence is not known to the third party. Say, for example, I am acting on behalf of Mr. Ambani, and I clearly specify that the transaction which I'm entering into is on behalf of Mr. Ambani. So, yeah, in this situation, I have disclosed my principal's identity. But say in another situation, I am acting on behalf of Mr. Ambani, but I do not specifically mention that I am acting on Mr. Ambani's behalf. So in that situation, my principal is undisclosed principal, and the third party would not even know that there's some principal in existence at all. So there are two situations where the agent is acting for a disclosed principal, and the second situation is where the agent is acting on behalf of an undisclosed principal. So where the agent acts for a disclosed principal. So when we say where the existence of the principal has been made known to the third party, we say that principal is a disclosed principal. And it is not necessary for the principal to be identified by the third party. The meeting between the principal and the third party is not necessary. So the contract, and as a general rule, we know that whenever an agent is entering into any contract, it is ultimately a contract between the principal and the third party, and the agent is not liable or he's not entitled under the contract. However, agent will be personally liable in the following exceptional circumstances. It is the liability of principal, but in certain circumstances the agent would be made personally liable. What are they? Where the agent showed an intention to undertake personal liability. So if say the agent has signed a contract in his own name and not in the name of principal. So in that situation, agent signing the contract in his own name gives an inference that he is ready to undertake a personal liability with respect to this transaction. So where the agent he has shown an intention to undertake any personal liability, or where it is as per the custom of the trade or trade usage that the agent would be personally held liable, or where the agent refuses to identify the principal, he refuses to give the name of the principal, or where the agent is acting on behalf of a fictitious principal. So there's no principal actually in existence, he's a fictitious principal. So in all these situations, the agent would be personally liable. Personal liability of the agent would arise in all of these situations. This is where the principal's existence is disclosed. Let's now talk of what will happen in case of an undisclosed principal. So when do we say a principal is undisclosed? It is basically where the existence of the principal is not made known to the third party. When the third party discovers the existence of principal, they can elect to treat principal or agent as bound by the transaction. So when the principal is not disclosed, it is as per the discretion of the third party. If the third party later on it discovers that there's some principal in existence, then they can decide to treat the principal or agent as bound by the transaction depending on the situation. Now let's talk of agent's fiduciary duty. Fiduciary duty, the term fiduciary basically means trust or genuine. So agent has a fiduciary relationship with their principal. Basically, it is a relationship of trust. And this is a position which is similar of that of a trustee, and it has following consequences. So agent must not allow their personal interest to conflict with those of principal. So agent should not allow their personal interest to conflict with the interests of the principal. It is not that someone is bribing the agent and the agent he enters into a transaction which is not for the benefit of the principal. So agent must not do any of these acts, and he should always act in the best interests of the principal. So agent, he should always make sure that he is acting in the best interest of the principal, and he must not make a secret profit. There shouldn't be any secret profit being made by the agent, and agent has a duty to account to the principal for all money and property received. So anything which the agent is receiving pursuant to the transaction which he is doing on behalf of the principal, the agent has a duty to account for all of this to the principal. He shall give details of any amount received, any property received pursuant to his relationship of agency to the principal. All these things shall be informed by the agent to his principal. And where an agent is in breach of their fiduciary duty, basically there's a failure to comply with their fiduciary duty, then what can the principal do? Principal can repudiate the contract with the third party. They can cancel the contract. Agent can be dismissed without notice. If he is breaching his fiduciary duty, the agent can be dismissed, and that too without giving any notice. The principal can refuse to pay any money owed to agent or recover any money already paid. So principal can refuse to pay any money. So whenever a person is acting as an agent, he is given some amount as commission. So in a situation of breach, the principal can refuse to pay any money to the agent. And also principal can recover any secret profit made or any bribe. So if the agent has made some secret profit or he has taken bribe from someone, the principal can recover all of these amounts as well. So this will happen when an agent breaches his fiduciary duty, wherein he acts beyond the interest of the principal. He does not act in the interest of the principal. Now, talking of what would be the liability which a principal would have against the agent. So the principal has to pay some amount as remuneration to the agent for the services which the agent is performing. So could be in the form of commission for the services which are performed. And in case there are some expenses which the agent has incurred, the principal is liable to reimburse all those expenses. And principal is also liable to indemnify the agent for all the expenses which the agent is incurring for the purposes of purposes of protecting the interest of the principal, and also for carrying out the obligations of the principal. And not only that, if the principal does not pay any amount to the agent can also exercise right of lien on the principal's property. So if the principal refuses to pay any amount, the agent also has a right, that is right of lien on the principal's property. So the agent has the right to claim remuneration or commission for the services performed, to claim indemnity against principal for all the expenses which are incurred for the purpose of carrying out obligations, and also exercise lien over principal's property. So lien basically means retaining the possession of principal's property which the agent has lawfully obtained till the time the debts which are due from the principal are paid off. So these are some of the liabilities which the principal will have against the agent. So with this, we've now understood the agency law in a brief manner, the basic elements of principal agency relationship, and also what are the different authorities which an agent have, and the duties, the liabilities of the agent as well as the principal. So we've understood all of this with respect to the agency law.
Hey, are you considering ACCA as a career path? Then you're at the right place. Call us at 9640 or log into indigolearn.com or download our app OneFin by IndigoLearn.